Brochim Habaim, welcome to you all. And with the permission of our Rosh Bedin, Dayan Abraham David, Dayanim, Rabbanim, distinguished guests, I would like to extend a very warm welcome to each and every one of you this evening. It's really a great pleasure to be able to chair this inaugural conference of Dayanim, hosted by the Sephardi Bedin of the Spanish and Portuguese Sephardi community, which promises to be a very exciting event. The theme of this evening's conference is the role a Bedin anywhere in the world can play in resolving monetary disputes by the interpretation and application of halakha. Financial disputes are not new, and in fact, just yesterday we read in the parasha of Moshe's father-in-law Yitro, and his suggestion to Moshe to set up a judicial system to engage with these issues. This is one crucial aspect of a Bedin, and one which we look forward to exploring this evening with our distinguished speakers. As well as attempting to resolve financial disputes, our Bedin deals with many other important matters, such as marriage authorizations, and unfortunately sometimes breakdown of marriages, queries regarding Jewish identity and their status, is one a Kohen, a Levi, Israel, facilitating conversions to Judaism, overseeing the kashrut of the SKA, the Sephardi Kashrut Authority, and issuing halachic guidance to the synagogues of the Spanish and Portuguese community, as well as the wider community. These past 12 months have been difficult for each and every one of us. Nonetheless, our Bedin has continued to fully operate throughout this pandemic, conducting the vast majority of its work through the aid of technology. And many of you may not have ever been to a Bedin, and for some, the Bedin remains a mystical concept, only to be used as a last resort. I can proudly say that our Bedin is accessible, transparent, and open to all segments of the Jewish community. And it's in this spirit that we have put together this conference to provide you with a taste of the workings of a Bedin. Please note, at the end of the conference, there will be an opportunity for participants to have questions related to the conference answered. And therefore, if you have any questions throughout the course of the evening, please do feel free to send a question in the chat box, and we will endeavor to answer as many questions as possible. We'll now move to the Divrei Bracha, opening words from the Rishon LeZion and Chief Rabbi of Yerushalayim, Harav Shlomo Moshe Amar Shelita, who has graciously provided us with a video message, which he recorded a couple of weeks ago. If we can now have this video shared.
לונדון כדי לחזק את הקהילה.
Sebastian, if we could restart the video, that would be great.
שמחתי לשמוע על הכינוס שבית הדין בראשותו של אברהם דוד שליטה עושים בלונדון כדי לחזק את הקהילה ולחזק את הבית דין. כשהבית דין של הקהילה חזק, זה חוזקה וחוסנה של הקהילה כולה. כל מקום שהרבנים הם תמיד חכמים וחזקים, זה מחזק את הקהילה כולה. ואחד הדברים החשובים, שהדינים והמשפטים, אם יש כאלה, צריכים להביא אותם לפני בית הדין שדן על פי דין תורה. ואלה המשפטים אשר תשים לפניהם אמרו רבותינו בגמרא, מה זה לפניהם? לפניהם ולא לפני ערכאות של גויים. ערכאות של גויים זה כולל כל מי ששופט, גם אם הוא יהודי, אם הוא שופט לו על פי הדין של התורה, נקרא ערכאות שאסור להישפט אצלם. על כן, כל מי שיש לו דין תורה, עם שכנו, עם חברו, בממונות, בירושות, מה טוב ומנעים תמיד לבוא לדין תורה. וגם אם יש צורך באישור של בתי המשפט האזרחיים האחראים על פי החוק, אפשר קודם כל לעשות דין תורה ואחר כך לתת לזה תוקף של אישור, זה לא דבר גדול. אבל בזה גם מקיימים את ההלכה. הרמב"ם כותב שמי שהולך להישפט בערכאות שאינם של תורה, הרי זה מרים יד בתורת משה רבנו. דבר חמור מאוד. לא ראינו בשום עבירה, מרים יד בתורתו של משה רבנו. השם יצילנו. וחוץ מזה, יש בזה גם חיזוק של הקהילה כולה. ברוכים תהיו בבשורות טובות.
Some sharp words from the Rambam with regards to those who bring their financial disputes before the secular courts, which really strengthens the whole purpose of this conference this evening of bringing financial disputes to a Beth Din. And we are also privileged to have with us a video recording from the current Chief Rabbi of Israel, the Ashkenazi Chief Rabbi, Rabbi David Lau, who has also recorded a message. If we could have that played now as well, please.
אחיי ורעיי, חברי בית הדין בלונדון, ידידי הרב דיוויד, ידידיי ומכובדיי הרבנים, מכובדיי כולם. אנחנו זוכים ערב שבת קודש פרשת משפטים, שבת שבה הקדוש ברוך הוא מורה לנו ואומר, אלה המשפטים אשר תשים לפניהם דווקא, לפני דייני ישראל, שידונו בדין תורה כהלכה. ומצורפת כאן גם האות ו' ואלה המשפטים. ומחברת אותנו האות ו' אל מעמד הר סיני, אל מתן תורה, ורש"י מדגיש מיד בהתחלה ואומר, והדבר ללמדנו, מה אלו מסיני הראשונים, אף האחרונים מסיני. כי ישנם כאלה שחושבים שאולי דבר השם, סיני, זה רק בדברים בין אדם למקום, רק בעניינים שנוגעים לאנוכי השם אלוקיך, לא יהיה לך אלוהים אחרים על פניי, סבורים וטועים שזה קשור אך ורק אל דבר השם שנוגע בעניינים בין אדם למקום, אבל חושבים שבין אדם לחברו, שם כבר יש את ההסכמות בני אדם, שיש כבר את הדברים שאנשים מחליטים לעצמם. טועים אנשים וחושבים שבדברים הללו אין צורך להגיע אלא אל מציאות פשוטה אחת, אל מציאות אחת של הבנת בני אדם, והיא הקובעת את הדינים. אבל אלה המשפטים הוא קובע הקדוש ברוך הוא, אלה המשפטים אשר תשים לפניהם גם זה מסיני, כי תקנה עבד עברי, גם שור רעך, גם האחריות שיש לך בשמירה, בדיני ממונות ובאחריות בכל הנושאים, גם זה ניתן מסיני, וגם בזה כלל וחובה על כל יהודי לדעת ולהיזהר בדיני ממונות. בשבוע הזה חל גם יום פטירתו של מייסד תנועת המוסר, רבי ישראל מסלנט, והוא כותב איגרת מפורסמת. באיגרת הוא כותב לו, יעלה על הדעת שיהודי שאני מכיר לא יאכל אוכל אלא בוודאי רק אם זה בכשרות, וגם אם הרב יגיד לו שאין ברירה, הבהמה אינה כשרה וצריכים את הבהמה הזאת, צריכים להפסיד אותה כי היא כרגע נבלה או טריפה, אדם יפסיד מכספו בקלות, לא יערער, לא יהרהר, אלא כשהרב אומר הוא יקשיב. אומר רבי ישראל מסלנט, ומה בהקשר לדברים בין אדם לחברו? ומה באשר לשכר שכיר? ומה באשר לדיני ממונות? גם זה לאו בתורה וגם זה. כפי שנאמר בתורה לא תאכלו כל נבלה, כך גם נאמר בתורה להיזהר ולהישמר שחלילה לא תעשוק את רעך ולא תגזול, לא תלין פעולת שכיר איתך עד בוקר. גם זה מסיני וגם זה מסיני. ואנו כיהודים שומרי תורה ומצוות רוצים לעשות רצון אבינו שבשמיים, והיות שכך אנחנו עושים את המוטל עלינו, והוא לעשות את דבר השם. אומר רבי ישראל מסלנט, גם בין אדם למקום, גם בין אדם לחברו, להיזהר בשני הדברים. ואלה המשפטים, גם אלו מסיני בדברים, הן בין איש לאשתו, הן בין דיני ממונות בין אדם לחברו, ולעשות זאת בדרכה של תורה, ולשמור ולשמר את דבר השם שיקום בעולם, כי מי שדן דין אמת לאמיתו, זוכה להיות שותף לקדוש ברוך הוא ממעשה בראשית. יהי נועם השם עליכם, סייעתא דשמיא תלווה אתכם, וכל אלו שבאים בשערי בית הדין, יזכו לשמוע דבר השם זו הלכה, ולראות את קיום דבר השם בעולם. ברכת שמיים תלווה אתכם, מתוך בריאות ושמחה, לכל אשר תפנו.
Beautiful words from the current Ashkenazi Chief Rabbi of Israel, Rabbi Lau. And it's a great privilege to be able to introduce the Rosh Bedin of our Sephardi Bedin, Dayan David. Dayan David studied at the Gates of Yeshiva and Kollel, as well as Bris Kollel and Yeshivat Porat Yosef in Yerushalayim. Subsequently, he led the largest Sephardi Kehillah and Kollel in Buenos Aires, growing the community tremendously. Over 30 years ago, he was invited to lead the Sephardi Kehillah of Od Yosef Chai, which has since grown into a Kollel for the advanced study of Halakha, as well as the Nancy Rubin Primary School. He has been a senior Dayan of the Bedin for over 20 years, and is now our Rosh Bedin. It has truly been my privilege to work under the Rosh Bedin for the last 5 years, and I'd like to hand over to Dayan Avraham David for some divrei bracha, some words of blessing. Bechavot, Kvod Dayan. Please unmute yourself, Dayan. Dayan, please unmute yourself. Bechavot.
Shalom ubracha. Thank you for kind words, Rabbi Kada. Shechiyanu v'kimanu v'gianu lazman hazeh. We thank God for giving us this, our Bedin and our community, the opportunity to present this conference of Dayanim. I think it's the first of its kind in this country for sure, that we brought together a kenus, a conference of Dayanim. And we hope that this will inspire other communities and other Bati Dinim to follow our initiative. We know a lot of effort has been put into this. All our volunteers, the office team, community leaders, senior rabbi, and all those who are participating in this Kiddush Hashem, this kenus of Dayanim. We've chosen the subject of Dini Mamonot, monetary disputes and halachot, to make aware our communities of this maybe not so recognized part of the work of a Bedin. There are other parts of the Bedin, other works in the Bedin, which are better known. But as most important, the Bedin have the ability and the means to decide on monetary arguments and disputes. We've chosen this parasha, Ve'ele HaMishpatim Asher Tasim Lefnehem. And here Moshe Rabbeinu is told about those laws which pertain between Adam lechavero. Things of disputes, monetary disputes. And there he's told, Asher tasim lifnehem keshulchan aruch. That it's not only learning or saying over verbatim, repeating many times halacha, making a list of halachot, but it's to teach us lasim lifnehem, to teach us and to give us that we should know the proper understanding, the sources of Jewish halakha, to understand them and the reasoning behind it, so that we should be prepared to face any halakha, to be able to judge any dispute according to the laws of the Torah. That Moshe Rabbeinu stresses this. We have to have the reasoning and the understanding from the sources. So we should be able to apply the laws and apply the judgments to every monetary case. You know, when two people come before Beth Din with a dispute, every case is unique. It is not like a standard halachot you find in another halachot, which applies to everyone. We have to treat every dispute matun, with deliberation, and to really look at it. No, I had this case to before and it's fine. No, you have two litigators before you. They have their own way of putting forward the case. And there might be small differences in what they're arguing about. It's a responsibility on the Beth Din to be able to have the means and to have the knowledge and to have the reasoning so that they should apply to every individual case, which is unique, the halakha of the Torah, or even in pishara, which is called compromise, which is form of arbitration. Even pishara has got to be taken according to the laws and laws of the Torah, the laws which apply to pishara, and we have to address them according to the Torah. Now let me tell you something. Not only here, Moshe Rabbeinu stresses that the Dayanim have to know, go all behind all the halachot, have them clear in front of them. The Torah is so particular. You know, when you have some sort of a psak you have to make, which has to do with Isur and Heter, Kashrut, even Shabbat, Yom Kippur, one witness can tell you the halakha, can tell you the decision. One dayan, one rabbi can give you the psak din, and you accept it. When it comes to dini mamonot, monetary disputes, the Torah demands 2 witnesses, the maximum, 2 witnesses, 3 dayanim, 3 judges to deliberate it. Because dini mamonot is so important. Why is it so? More than eating tarif, more than eating on Yom Kippur, more than Shabbat, Chilul Shabbat. Why does the Torah demand such stringency? That 2 dayanim, 2 witnesses, 3 dayanim. Let me explain. You know, Chazal Ish, among many great gedolim, explain this. When you have a dispute between 2 people or more, then, you know, it's not like a psak halakha for tarif, kasher, Shabbat. You know, even a person, it's not a matter of money, amount in question. A person can lose an animal worth 1,000 pounds because witness says it was not, the shechita was not done properly. Or rabbi says it's treif. We can lose a lot of money when it comes to chametz, shavar ala pesach. Thousands of pounds. And one rabbi one witness can decide, make a decision. And you know what? In human nature, we accept it. We accept it, and you know, it's a big loss. But what should we say? And we say, kapara. It's happened, we give it. Okay, that's the decision. God wants it to be done like that. Lost it. But when it comes to dispute, a monetary dispute, then that's not a simple taref and kasher. When one person is zocheh, when one person is given a decision that he is zakai, he's right, the other person loses out. His opponent, his litigator, loses out. And that hurts terribly. To give away money, you lose it. Shem Shamayim, it does it. But that I lose something and my opponent gains it, that bothers us in our psychological, in our human nature. And we really don't accept it. We find it hard to accept. There the Torah demands the highest standards of proficiency for the Dayanim and higher standards of who can give witness and how many Dayanim there should be. Yes, this is the importance of our Jewish litigation, monetary dispute. But let us say this, that Baruch Hashem, that din has proved itself working well in monetary disputes as well. We say that even for the smallest amount, we need two witnesses, Dayanim, who are proficient. Jewish judgment, a judgment when the litigants have to stand before us. And we, the Dayanim, understand that it's not a decision which is only with us. God stands in the Adat. When we have a Din Torah, then Hashem is present. A Dayan is not only a profession. A Dayan serves God, and he serves Klal Yisrael, the Jewish people. It's a service. It's not just a profession. And that service, we are responsible. And we have a responsibility and to answer to Hashem. That's why Dayanim have to be God-fearing. And really, this is one of the greatest aspects of Judaism. Jewish court, we judge. We can judge al-Pidin Torah. We can judge Shara. But it's all according to the laws of Moses and Israel, according to those guidelines. Say that Jewish judgment, our judgment, is a judgment which brings peace and harmony to Klal Yisrael. Emet, if we're judging according to the strict laws of the Torah. And Shalom, if we make Pishara, if we make compromise. Emet fi Shalom ehavu. And this brings truth and peace to all Klal Yisrael. We wish to thank all those who worked so hard for this conference. And we wish to thank the great Gaonim, Rab Shlomo Amar, the emeritus chief rabbi and Rav of Yerushalayim, Rab David Lav, the chief rabbi of Israel, and Rabbi Weiss, who's going to give us, is always ready to help and to give us his input into this wonderful conference. I wish to thank all our Dayanim who we will be hearing from them. They're doing for really taking so much effort, taking so much organization. And we say to all of you, all the community, its leaders, for giving this opportunity, to merit Klal Yisrael, to be aware of the greatness of the Jewish court, Beth Din, and all that takes place in it. Shalom ubracha.
Thank you very much for those inspiring words, Rosh Beddin, Dayan David. I can say from my experience that Dayan David exemplifies what he just talked about. Hevu metunim badin, be deliberate, always thinking things over and over again, asking and making sure that everything is right, al pi halacha v'al pi adin. And Baruch Hashem, we are zocheh to have Dayan David serve us as the Rosh Beddin. Moving on to our next speaker now, it's a tremendous zechut and kavod for myself and for the entire Spanish and Portuguese community and Sephardi Beddin to be able to welcome one of the greatest poskim of today's generation. Harav HaGaon Havasher Weiss is amongst the most renowned and respected halachic authorities today. A true Gadol b'Israel, his unique blend of extraordinary Torah knowledge and profound insight has impacted thousands around the world across the entire spectrum of Torah Jewry. Senior Rabbanim, engineers, educators, doctors, lawyers, and people from many other professions regularly seek his halachic guidance in their fields of expertise. A prolific writer, Harav Weiss has published more than 30 volumes in his Minchat Asher series covering all areas of Torah and Halakha. I personally frequently avail myself to the works of Rav Weiss, and in this sense, I can consider myself a Talmid of the Rav. I want to add one further point, and that Harav Weiss's halachic guidance over the past 12 months has been such an inspiration for many of my colleagues and myself. So often, we waited to hear balanced psakim, guidance in the difficult situation which we all find ourselves in, and never once did the Rasha fail, always making sure that he gave us the correct halachic guidance, and for us to continue to be an Or LaGoyim, a light for the nations. And we're truly lucky to have him with us. And without further ado, I'd like to welcome Rav Asher Weiss to share with us, keynote speaker, his words of Torah, Bechavod.
Thank you. And I very much appreciate this opportunity, the honor and the privilege, the kavod to address this important assembly, virtual assembly. I wish I could be together with you. We could see each other, shake hands with each other, embrace each other, and just converse on my way in and on my way out, as we always do. As we did in the past, and B'siyata D'Shmaya will do in the future. But right now it is not to be. We are still in the midst of this terrible pandemic. And let us all pray and daven and hope that HaKadosh Baruch Hu will take it away. I know that the situation in England is difficult. In Israel, it's horrific. We are in the midst of a huge wave. And it's a paradox. On the one hand, we're leading the world in vaccination. On the other hand, we are at the worst stage of this pandemic because so many people are not yet vaccinated. So let us hope that this Kenneth will not be just one time. And next time, I will be able to share with you and be together with you. So thank you once again. And I especially want to thank the Av Beit Din, HaGaon, Rabbi Avram David Shlita. We are in touch, and from time to time, we share Torah perspectives on relevant issues. I'm familiar with the work of this great Beit Din, probably the oldest Beit Din in the United Kingdom. I know this Beit Din goes back approximately 200 years, to the best of my knowledge. And it really is a great Beit Din. I know the Av Beit Din, I know the Dayanim. And I think the Kehillah in London should be proud of this Beit Din. And I also think it's an extremely important initiative and endeavor. The Navi Malachi says, אז נדברו יראי השם איש אל רעהו, ויקשב השם וישמע. When we come together to discuss relevant topics and to seek Torah guidance and the guidance of our Chachamim, it is not only we that listen one to another. Hashem is with us, and Hashem listens as well. Az nidberu yirei Hashem ish re'ehu, v'yakshev Hashem v'yishma. I once wrote a tshuva, and I discussed an interesting question. Is there kedusha in the cheder Beit Hadin, in the room where the Dayanim sit, and people come before them, defendants and claimants? Does that have Kedushas Beit Midrash or Beit Knesset? In Megillah Daf Chavav, there's a machlokes in the Gemara. Beit Knesset ve Beit Midrash, Beitei Knesiot, are designated for Tefillah, Batei Midrashot for the study of Torah, which has a higher level of Kedusha. And that is a question discussed in Megillah Daf Chavav, Shulchan Aruch Orach Chaim Kuf Nun Gimel. The halacha is, a Beis Medrash has a higher level of Kedusha than a Beit Knesset. Obviously, Torah even comes before Tefillah. Bezohar HaKadosh, many different sources. The Zohar deals with the very second Mishnah in Masechet Avot. Shimon HaTzadik היה אומר, על שלושה דברים התורה אומר, העולם עומד, the three pillars of the world, Torah, Avodah, Gemilut Chasadim. However, the Zohar says, the central pillar is Torah, Avodah and Chesed, miyamin u'mismal, from right and from left. Supplementary pillars to the Amud HaTavach, which is Torah. So it should need no wonder that a Beit Midrash has more Kedusha than a Beit Knesset. However, there's another Gemara in Brachas Daf Ches, Ohev Hashem Sharei Tzion Mekol Mishkanot Yaakov. And the interpretation we find in Masechet Brachot is, Ohev Hashem Sharim Ametzuyanim Bahalacha. Yoter Mekol Mishkanot Yaakov Batei Knesiot Ubatei Midrashot. So there is something that has even a higher degree of Kedusha than both Batei Midrashot and Batei Knesiot. And what is that? Sha'arim hametzuyanim b'halacha. And I think that a Beis Din definitely answers to the definition. Sha'arim hametzuyanim b'halacha, because it is here, it is there that we pass judgment. Halacha lemaisa. Elohim nitzav ba'adat el. So the Pasuk says, a Kodesh Baruch Hu dwells in a Beis Din. Both in Bavli, Brachas Davav, and Yerushalmi, Sanhedrin Daf Zayin, we find Chazal speaking to Dayanim. You should know lifnei mi atadan ve'et mi atadan ki'ilu danim et HaKodesh Baruch Hu. And it is the Kodesh Baruch Hu standing over us and observing what happens in Beis Din, and therefore we need an extreme level of Koved Rosh, hoping and praying for Siyata Dishmaya. And yes, Az Nidberu Yir'ei Hashem. And our Dayanim should have the highest degree, not only of Torah knowledge, but of Yirat Hashem as well. I quoted the Mishnah in the beginning of Masechet Avot, Perek Aleph Mishnah Beis, Shimon HaTzadik, Al Shlosha Dvarim Ha'olam Omed, Al HaTorah, Al HaAvodah, Al Gemilut Chasadim. But the very last Mishnah in the first Perek of Avos is another statement. Mishnah Yudchet, Rabbi Shimon ben Gamliel Omer, Al Shlosha Dvarim Ha'olam Kayam, Al HaEmet, Al HaDin, Va'al HaShalom. And many early commentators ask, what is the difference between the two? So let's try to translate into English. On three things, on three pillars, the world stands. For three things, the world exists. Ha'olam omed, the world stands on Torah, Avodah, Gemilas, Chosodim. But the world exists in the merit of Ha'emet, Hadin, V'Shalom. And let me share with you a chiddush. It is not only one out of the three that is associated with Beit Din. It is all three. Ha'emet, Hadin, V'Shalom. These are the three fundamentals of the duty of a Beis Din. I cannot speak at great length. You have many speakers tonight. And I was designated a very short time of 1/2 hour. But we learn from the greatest poskim that the duty of a Beis Din is not only din. It is the combination of emet, din, and shalom. Tshuvot Arosh, Klal Tzaddik Zayin Siv Gimel. Sometimes Beis Din used to use its wisdom, its intuition, its feeling, its musar guidance to know to achieve emes, and sometimes not always in the means of the classical tools of din. And there's another tshuva in Rosh, Klal Kuv Zayin Sivav, that Beis Din needs to bear in mind what will happen between the people after they pass their verdict. Will they cause more strife, more machlokes, more hatred, more fighting, or will they bring peace and harmony to people? And that, once again, is the responsibility of Beis Din, enhancing shalom ben adam lechaveroi, ben ish leishtoi. And this rush is quoted in Hilchas Dayanim, Siman Yud Beis Sif Hey. Ner leraglei hadayanim, their guiding light should be choshen mishpat. There are botedim that always strive to psharas. And in many times, it is because some of the Dayanim aren't really familiar with choshen mishpat. And they are God-fearing Jews. So they will always try to make a pshara. Not always is it justified. The guiding light needs to be choshen mishpat. But many times, yes, Beis Din should try to suggest compromises to enhance peace and harmony. I will make my tshuvas on these topics available if you ask for them, because I did write many important tshuvas. When is it recommended to try to suggest a pshara? And when should our approach be Yekov Adin et Ahar? So there are certain guidelines. We don't have the time to discuss that matter at length, but I will make my tshuvas available at your request. So it was suggested that I speak about lawyers and Toanim Rabbaniyim in Beis Din. Is it a recommended practice? Is it right? Is it wrong? Is it just we have no choice? This is a legal requirement and possibility, or should it be encouraged? This question touches upon three fundamental sugyas. Masechet Avos, Perek Aleph, Mishnah Ches. Yehuda ben Tabai omer al ta'as atzmachu ka'orchei hadayanim. Shavuos daf lamed Aleph. Asher lo toiv asa ba'amav, ze haba b'harsha'a. A person that comes to Beis Din on the behalf of another, not with his own issues, but as an agent to represent another person. And the Gemara says, Asher lo tov asa ba'amav, ze haba b'harsha'a. These two sugyas, according to many Rishonim, deal with the question, is it right for a person to come to Beis Din to represent an other? The other side of the same question is it right for a Beis Din to let the Balei Din off the hook and let them be represented by professionals? As I mentioned, three different sugyas. Choshen Mishpat Kuf Chav Gimel Sif Tet Vav, we find the halach of Baba Harsha'a. The Rama writes that if the Shaliach, the lawyer, or anybody that represents one of the Balei Din, whether it's the claimant or the defendant, does so l'shem mitzvah, then he's doing a great mitzvah. It's a virtue. It depends why he is here and what are his intentions. So if he's just coming to fight, that is bad. Alav, Amru Chazal, lo tov asa ba'amav. So this is a lengthy discussion. Shach Sif Kod Lamed Beis, Chazon Ish, Choshen Mishpat, Siman Gimel. I'm just sharing with you my maskana, the conclusion la halacha. If a person comes on the behalf of another, he needs to be honest with his sender, with the Dayanim, and primarily with the Kodesh Baruch Hu. You cannot lie in Beis Din. You cannot manipulate Beis Din, even if it means losing $100,000. That is the difference between lo tov asa ba'amav and a person that's performing a mitzvah. So the din of Baba Harshoah is a Gemara in Shavuos Lamed Aleph. And the very first perek in Avos, Al tas atzmacha k'orchei Dayanim. Fundamentally, Masechet Avos is not about halacha. It is about midot tovot. It is the only Masechet in the entirety of Shas that does not deal with halacha. It is the virtues of our fathers. So when Chazal say in Avos, Al tas atzmacha k'orchei Dayanim, is that a halacha or is it Musa? The great commentators on Avos interpret it as Musa, not as halacha psuka. Rabbeinu Yonah, in his Perush on Masechet Avos, says, why shouldn't the person represent another in Beis Din? Mupnei hachashad. What will people think? Why are you here? Are you getting a kickback? Are you getting shochet? Are you here to manipulate? Why just don't you let the party come himself? If he's honest, what is he afraid of? So Rabbeinu Yonah's interpretation is chashda, chashad. What will people think about you? The Meiri, on his commentary on Avos, says, you're going to teach people how to lie and manipulate. You're going to teach people to be dishonest. Just let them come in Beis Din and speak from their heart. Speak truth. So both the Meiri and Rabbeinu Yonah seem to offer a Musar interpretation. There's another Meiri in Shavuos Lamed Aleph, and that Meiri says the Mishnah and Avos and the Gemara and Shavuos are one and the same. Two sides of the very same coin. Why would you get involved in a dispute which you have no part in? You are gonna bring more machlokes. If you care for people, try to bring them together. Try to bring them to compromise. Coming to Beis Din to speak on the behalf of one party is just deepening the rift between one person and another. So we have three different interpretations. But what is important to bear in mind is that Rambam Perek Kuf Aleph Chot Sanhedrin, because the Shulchan Aruch follows in the footsteps of the Rambam. And according to the Shulchan Aruch, this halacha, al ta'as atzmacha korchei dayanim, does not speak to the lawyers. It speaks to the Dayanim. And what Chazal teach us, the Dayanim need to be totally impartial. Totally impartial. Be more passive than active. Yes, you need to question the parties. You need to question the Eidim that will come before Beis Din, people that come to testify. But be very careful in giving the same attention to both parties. And don't try to help one of them present his arguments. Let them speak for themselves. So according to the Rambam and the Shulchan Aruch, Maran Abeit Yosef, following in the footsteps of the Rambam, Perek Yud Zayin, Hilchos Dayanim, it is not speaking to the representatives, but to the Dayanim themselves. And this is a machlokes between the Rambam and the Torah, and it's fascinating. How exactly does a beis need to conduct its affairs? How active should Dayanim be? Ptach picha le'ilem. The Rambam is a machmir, but he says, if beis din sees one of the parties either is afraid, he feels intimidated, or he just stutters, and he has difficulty presenting his argument and his case, beis din could help him along, but not speak on his behalf. So this is a very delicate and fine line. It's like walking a tightrope. Yes, beis din sometimes would encourage a person to explain what he's trying to convey. But we need to be very careful not to turn one party away and give him the feeling that we lean towards the other side. So is it justified for a person to come to beis din with a lawyer or a to'en rabbani? It depends on the interpretation of al ta'as atzmacha korchei dayanim. And even if orchei dayanim speaks to the beis din, not to the representatives, but there still is the Gemara bo b'harsha. But I quoted the Ramon Kuf Chav Gimel. If it's l'shem shemayim, it's justified. And the fact that you're being paid doesn't disqualify you. It's legitimate. You're being paid for your time. You're being paid for your effort. You're being paid for your expertise. But it needs to be l'shem shemayim. You cannot come to beis din in a dishonest fashion. Midvar sheket turchak. A lengthy sugya Masechet Shavuos. It applies to all different aspects of beis din. So a lawyer or a to'en rabbani needs to be aware, I think once in a while, once in a month, 2 months, 3 months, 5 months, 6 months, once in a year, he needs to check his balance. How many tikim did I turn away? If you took them all, tzorech bedika acharov. If you turned away 50%, then you might be okay. Which were the ones you took and which were the ones rejected? Did you take the ones that offered the most money? Tzorech bedika acharov. You could only take those which you are convinced that they are right. And you're doing it l'shem shemayim. You're entitled to get paid, but it needs to be l'shem shemayim. In Shulchan Aruch, many poskim differentiate between the teveh and the nitva. The claimant could send an agent to speak in his name, not the defendant. However, the Ramah, in Shuvas Ramah, Siman Kuf Daled, following in the footsteps of the Ramah Nachlas Shiva, Shtarot, Siman Chav Daled, the Tumim, the great Rabbi Yonis and Eibeshitz, Kuf Chav Daled, Sif Kot Nalef, the Orcha Shulchan, they all write, the minhag is that both the claimant and the defendant could bring a lawyer or a To'en Rabbani. It is the same. So let me tell you my minhag in my Beis Din. I would insist that the parties come. They could bring lawyers with them. But if it is at all possible, I would insist that they come as well. It's not always possible. Sometimes they're in a faraway country. Sometimes they're ill. Not always is it possible. But if it is possible, I would insist the parties come. And I would demand from the claimant and the defendant to at least tell their story. And then they could let the lawyers take over. But I want to have a personal impression from the parties. Just tell me what happened. Just tell me the story. Yes, the lawyers would be there. They would present the arguments. But I think it is important that the Beis Din has a first-hand impression. Don't let lawyers or Dayanim run the show and take over the scene. So our minhag is yes. And I actually think that lawyers and Dayanim do a great service to Beth Din. Let us be honest. Let us be honest. Most Dayanim and Rabbanim are overworked, underpaid, overburdened. They have so much to do. So I'm an Av Beit Din for the past 20 so years. But I do many other things, as most of us do. And sometimes lawyers and Dayanim Rabbanim are very helpful. Helpful not only for the parties, but for the Dayanim as well. But you need Dayanim that have authority. In my Beis Din, I have a word that I say. In Lashon Kodesh, it sounds very well. It's like a play of words. I can't really translate it into English. But you all are familiar with Lashon Kodesh. בבית הדין שלי כולם מרגישים בבית. אף אחד לא מרגיש בעל בית. It's obvious who is the בעל bait. It is obvious to everyone that steps into the Beis Din room who is in charge. It is obvious who is the authority here. And I make an effort, everybody should feel at home, not to be intimidating. Lo lahatil eima yetera. But I make it very clear who's in charge. And I do not let lawyers or Dayanim try to take over the show and to intimidate the Dayanim. And that is very important. It depends on the Dayanim. I think that lawyers and Dayanim sometimes could offer a great service. And sometimes Dayanim Rabbanim present us with halachic material, and I say to them, thank you. Sometimes it's really helpful. Sometimes. And I read carefully all the materials that are presented to us. So, yes, the minhag is that there are two different things. I don't like the fact that Dayanim come and leave the Baalei Din at home. No, that is ivut hadin. We need to be able to impress indirectly, directly to be impressed by the Baalei Din. And that's why I would insist, I want you to come a base and you could bring along your lawyer. And sometimes I will turn to the Baalei Din and ask, I want you to say what you have to say, not only your lawyer. So Baalei Din are different than courts, than civil courts or state courts. In court, if your lawyer speaks, and the claimant or the defendant could be totally silent. I think a Beis Din should have a more natural flow of things, less rigid, less bound by protocol, and just seeking to achieve the truth. Al שלושה דברים העולם קיים, על האמת, על הדין va'al hashalom. So it's a privilege to be with you. And I will always try to be helpful in as much as I can. It's a schus for me. So if you will request, I'll send you the tshuvas I wrote about the various fundamental issues regarding how a beis din is supposed to conduct its affairs. And let me just end my very brief shiur with a bracha. First and foremost to Rabbi David. Kodesh Baruch Hu should give you many more wonderful years. Ladun, lehorot, lagdil Torah ulahadira. And to my dear friends, Kol Chavrei Beit Hadin. And all the other Dayanim who are with us in this beautiful event, this beautiful virtual endeavor. You should all have siyata d'shmaya. And all the others that are with us tonight. We should all have great siyata d'shmaya. HaKadosh Baruch Hu should be with us. Shelo nikashel b'dvar halacha. HaKadosh Baruch Hu should take this magefa away. And we should all be zeicher together. L'kadesh Shem Shemayim. Good evening to all of you.
Amen. Thank you very much, Avasha, for fascinating analysis of the role of Dayanim. Really, I learned so much personally. I'm sure everyone else did as well. Very interesting, the contrast between the Beit Din and secular courts, the importance of the actual claimant and defendant being there. And there's already been a request for the teshuvot, so I'm sure we'll arrange the exact.
And it should be a beautiful hemshech.
I go to Shkoyach. Thank you very much.
Kol tov, all the best.
Kol tov, kol tov. Great. So that was very interesting. And now we move on to the next topic, which is the theory and implementation of the Beit Din in the modern world, a discussion between Lord Wolfson, QC, and Dayan Dedun. So Lord Wolfson was born in Liverpool in 1968. He went to King David High School in Liverpool and spent a year at Yeshivat HaKotel in Yerushalayim. And David read Oriental Studies and Law at Selwyn College, Cambridge, graduating in 1991. David attended the Inns of Court School of Law, where he was awarded an Inns of Court scholarship, as well as a major scholarship from the Inner Temple. David was called to the bar at Inner Temple in October 92, where he is now a bencher. Lord David Wolfson of Tredegar, QC, was appointed as a minister in the Ministry of Justice in December last year. So a big mazel tov on behalf of the entire Beit Din and everyone here this evening, Lord Wolfson, on your recent appointment. And I think you were scheduled to join us for this conference before you were nominated as a Lord.
Yeah.
So it's nice, despite you becoming a Lord, you still decided to come. Dayan Avraham Yaakov Dedun is a Dayan of our Beit Din, qualified in Even HaEzer with experience in the Beit Din of Yerushalayim. Born and raised in England, Dayan Dedun spent many years in yeshivot in both the UK and Israel, where he received the semicha from the Rabbanut of Israel. Dayan Dedun has also been involved in numerous outreach, charity, and rabbinical projects, and is the Rosh Kollel Dayanut in Yerushalayim. Without further ado, I pass on to you both and look forward for this interesting conversation. Bechavod.
Thank you, Rabbi Kada. It's a great pleasure to be here tonight and together with Lord Wolfson. The plan is that we're speaking separately, and then B'ezrat Hashem after will be questions and answers together. Lichvod Rosh Beit Hadin, Mori v'Rabbi, Rosh Beit Hadin, Dayan David Shilita, to the esteemed Dayanim and Rabbanim, wherever you are around the globe, Bruchim Habayim, B'Shem Hashem. This pandemic has really proven very difficult to all of us, but to try and really, make the most of it, I think we have to look at the bright side. That I don't think without the pandemic, we wouldn't be here today to really make this conference happen. And to utilize this, B'ezrat Hashem, I think it's a big Kiddush Hashem and the first one, I think the first international conference of Dayanim outside of Eretz Yisrael. In this week's parasha, we open with the following pasuk: Ve'ele hamishpatim asher tasim lifnehem. These are the laws that you shall set before them. As the Rishon LeZion and the Chief Rabbi mentioned earlier, the Gemara in Masechet Gitin in Ein Het Amud Bet states that before them means that disputes should be placed before a Beit Din and not before the non-Jewish courts. We understand from here how vital this is. That not only is it preferable to go to a Beit Din, but in fact the Torah prohibits going to non-Jewish courts. It is evident that our Holy Torah contains within it a comprehensive legal system that is special and unique only to the Jewish people. The question arises here, I'm sure you've all asked it before, the principle, Chochma bagoyim ta'amin, that one should trust and believe the wisdom and knowledge of other nations. If so, why should we not learn from them and conform to the legal systems created by the other nations of the world? These legal systems are robust, well established, and have provided great economies with reputable legal infrastructures for many, many years. Why should we not learn from them? Chochma bagoyim ta'amin. This question is actually posed by the Al-Shich HaKadosh, a renowned 16th century rabbi. Secondly, if Jewish monetary laws and our legal system are really so special, then why do the nations of the world not come and learn from us? Let them come and learn the optimum and indeed correct way to arbitrate monetary law in society. Therefore, really, the central question that I want to address here tonight is what is so special about the monetary laws and the Jewish legal system that the Almighty has given us? What makes it so unique that the Torah goes so far to command us not to be judged by non-Jewish courts? Lifnehem velo lifnei akum. In order that we can really grasp this phenomenon, to understand this concept, one needs to first clarify that when establishing a legal system, the main question at hand that needs addressing is what are the values and principles upon which it will be based? What precisely takes precedence when creating a legal system? It's important to note, often people think differently, but the Jewish legal system will of course present a number of similarities to other legal systems in the world. But the Jewish legal system differs from all other secular legal systems due to the unique values that shape the Jewish legal system. Let me explain. Lifnehem velo lifnei akum, of course, like the Rabbanim said before me, HaKadosh Baruch Hu is together with us in Beit Din, and that's already enough reason to come. But on a rational level, in Parashat Ve'et Chanan, the pasuk denotes our legal system in the following beautiful words: Umi goy gadol asher lo chukim umishpatim tzadikim kechol haTorah hazot asher anochi noten lifnechem hayom. It says, what great nation has laws and rules as righteous as all the Torah that I set before you this day? Chukim umishpatim tzadikim. Let's focus on these words together. The Torah does not exalt its legal system for being correct or being wise, but rather for being a righteous one. Tzaddik, as everyone knows, means righteous, which actually stems from the word tzedek, meaning justice. Tzedek, justice, in the Torah's terminology, means to give the claimant or the defendant what is rightly due to them, as Rav Asher just beautifully explained. This, in fact, if we look closely, are the values that place the Torah's legal system so different from other secular legal systems. Other legal systems also strive for truth, for justice. After all, the courts are called the courts of justice. The difference being that it's not placed as its top priority. You would hope truth and justice go hand in hand. However, as we all know, the purpose of a civil trial is to decide whether the claimant has established his rights to the relief he seeks on a balance of probabilities. In a criminal trial, the question is whether the Crown or the state or the people have established beyond reasonable doubt that the defendant is guilty. Neither, therefore, ask the question, what actually did happen? What is the truth? To that extent, a court process is not a search for justice. Rather, it is a decision whether the claimant or the Crown has made out their claim or charge. Therefore, Morai Rabotai, each system, each legal system has its own scale of values, sulam ha'arachim, as we say in Hebrew, that extensively expresses itself in its foundation. Let's take the fundamental principle of finality. Finality in law is the concept that disputes must achieve a resolution from which there's no further appeal. Finality is important because a court cannot have outstanding cases that have no end. Cases have to end. Leaving cases open is just unjust. One of the biggest enemies of the economy is uncertainty. Thus, the ambition is that every case must end with a conclusive decision. There are appeals, of course, but after the final appeal, the hearing is over and the case is closed. Let's just explain this further to understand this principle. A business owner is taken to court and was then exonerated, he was pardoned. If he has to continue to live in fear that the case is not terminated, it places him in a position whereby he will always have to set aside money in the event that he may still be required to pay the claim. At some point in the future, can you really live like that in that way? Therefore, the civil justice systems determine that the finality of the hearing and the efficiency of the system is being of primary importance. A result of finality is what we know as the statute of limitations, hityashnut. A statute of limitations, as is known in secular legal systems, is the maximum time after an event that the legal proceedings may be initiated. You can't just wake up 10 years later, I want to take you to court. The purpose and effect of statutes of limitations are to protect the respondents so that they will not live in fear of being taken to court many years after the incident. Finality and the statute of limitations of primary value in the scale of secular legal systems. For further references on this, there are many in further detail. Stephen Landsman's writings in Adversarial Justice, and I've seen many more, reciting this point as being a primary value. On the other hand, Morai Rabotai, Jewish law, Choshen Mishpat, as established in the Mishnah in Masechet Sanhedrin, Lamed Aleph 31a, takes a very different approach. Says the Mishnah, Kol zman shemevi ra'aya soter et hadin. The Mishnah says that any time one of the litigants brings an additional proof, he can overturn the judgment that was given in accordance with the previous proofs. Rabban Shimon ben Gamliel says one can still overturn the verdict. Why? Because what is a litigant meant to do if he did not know that he has witnesses and subsequently found witnesses, or he did not know that he had proof and subsequently found proof? Therefore, he can still overturn the verdict. The halakha is like Rabban Shimon ben Gamliel. This is directly contrary to the principle of finality. Therefore, there must be a resolution that needs to be made on the scale of values, the sulam ha'arachim in law. And what do I actually call justice? Biblical references to the word justice means to make right. As a search for justice in Jewish law is of optimal precedence, even if it will be contradictory to finality and to the statute of limitations, it will take precedence. However, in other legal systems, a court process is not a search for justice. Rather, it is a decision as to whether the claimant or the crown has made out their claim or their charge. Let me explain. Given the above, and just to balance this point a bit, the Rosh, one of the main Rishonim in his response to Tshuvot HaRosh, quoted in Choshen Mishpat, Siman Samech Aleph Siftet in the Ramah, says as follows: Im shtar yashanhu, if it's an old bill, an old receipt taken out in court, an old proof, כמו שרגילים בארץ הזאת להוציא שטרות ישן נושן, ליבי נוקף תמיד עליהם, my heart always is nervous. והאמתלאה גדולה היא, אם לא היה תחבולה, למה שמרו זה ימים רבים, אם לא כדי שתשכב ותשתכח התחבולה, ואז יוציאנו. If there was any deceit or forgery, why was it not brought before the Beit Din till now? Goes on the Tshuvot HaRosh to say, Ra'ui ledayan, it is proper for a dayan, b'chol din she'yir'eh lo meruma, that if he sees any deceit in any judicial case, lirdof chesed, to pursue justice, ulotzio la'amito, and bring out the truth. We see that the Rosh elucidates that even if we do not have the principle of finality, there is still no room for deceit. So on the one hand, there is no limit for presenting evidence. However, on the other hand, we must be wary of the pitfalls this can actually cause. Receipt, deceit, and forgery can definitely be pitfalls that the Dayan has to be aware of. Just to delve deeper into this theory, that's in all Choshen Mishpat we find this, that the Torah is of the understanding that a person is responsible for his actions without any limit of time whatsoever. A person must be righteous all his days to his utmost capability. Therefore, if someone has acted unlawfully, even many, many years ago, he has to be judged and punished accordingly. So too, even if the case is finalized, if new evidence is brought to the courts, then the Beit Din will return the hearing and the injustice will be rectified, as the justice is of primary importance. The value that the injustice will be readdressed is more important than the value of the finality of the hearing. In summary, we've seen that the secular legal systems, the principle of finality prevails in order to create order and efficiency. The word justice in Jewish law means to make right. In secular law, justice means the maintaining of social order. There are many more examples throughout the Jewish legal system that shows the ultimate goal of justice, to achieve justice. As Rav Asher Weiss just explained regarding the necessity of hearing the defendant himself and not only his lawyer. Why? Because I need to listen to him. There was actually a Beit Din in Yerushalayim that began hearings, and very interesting, after several hearings, the claimant just disappeared. The Beit Din tried to call him several times, just disappeared. Searching for him, the Beit Din found that the claimant was caught for theft and imprisoned. This didn't allow the Beit Din to continue with his claim, as the parties could not have been heard directly. We see that to issue a verdict that is unjust, which they could have easily done, prevails over the respondent's feeling that his justice has come to an end. Also, the adversarial legal system, as opposed to the inquisitorial, as it is in the UK and the US, shows that the judge is there to hear the claims, not to seek what actually happened. Also, we also find where there's any room for experts needed, the work of the Beit Din is to bring the professional information needed and the combination of experts, mumchim, as is brought in Choshen Mishpat. The job is not of the claimant, of the Beit Din is to bring this professional information in order to get to the justice. Also, we find in the Machuta that the Torah takes into account the laws of the country. Of course, these are just a few examples of many, but it is clear that the fundamental and optimal principle upon which the Jewish legal system is established is to reach justice in the best possible way. Now that we have summarized the theory behind the court system, the Beit Din system, the Jewish legal system, the next lecture given by Lord Wilson or Tredegar will deal with how to apply this in today's world and how Dayanim can conduct themselves properly so that their decisions are applied legally. I would like to take this opportunity to wish a hearty Mazal Tov to my dear friend David. He has recently been appointed as a parliamentary Under-Secretary of State for Justice at the Ministry of Justice at the end of last year, and was introduced to the House of Lords as Lord Wolfson of Chedica, and is one of the only Shomrei Shabbat Jews in the government, in the House, and in the House of Lords, and it's a great asset for the Anglo Jury. Bechavod, and thank you for listening.
Thank you very much, and it's a very great pleasure to join this very distinguished lineup of panelists today. I confess I feel somewhat out of my depth. I'm not a rabbi, let alone a dayan, but I am a barrister, and also I'm a government minister, but I'm speaking this evening as neither. I'm not speaking as a barrister because for the duration of my ministerial appointment, I'm non-practicing, and so I can't give any legal advice, even if I wanted to. And I'm not speaking as a government minister because what I'm going to say is not really directed at or a question of government policy. But I do have the inestimable benefit of a weekly chavruta with my friend Dayan Dadun, in which we cover topics relevant to Jewish and English law. He's spoken of the legal theory underpinning the work of a Bet Din. I want to take the other side of the topic, which is the implementation bit. How does a Bet Din fit into today's legal world? I'm not talking about ritual issues, matters of kashrut, of personal status, or gittin. I'm talking about the Bet Din sitting as an arbitral body. And because there are some, at least, I hope, non-lawyers attending this conference, let me explain what I mean by arbitration. Arbitration is not mediation. Arbitration is not a without prejudice chat to see if you can settle the dispute. An arbitration is a binding hearing before an arbitrator, or usually a panel of arbitrators, which results in a ruling, usually called an award, which is enforceable. The arbitration, however, is normally held in private and is generally confidential. Critically, parties can choose their arbitrator. And so when the Bet Din sits as an arbitral body, it does so as a tribunal under the Arbitration Act 1996. That is a magnificent piece of legislation because what it does is it gives to the parties and the arbitrators, the tribunal, a large measure of freedom as to process and procedure. But critically, the award, when it's given, can be taken by the winning party to the court, the English court, and then enforced just as if it was a judgment of the English court. So it will have effect nationally because it's like an English court judgment, and also internationally because it can be enforced through what's called the New York Convention. So an arbitral award can be enforced very easily on an international basis. The judiciary and legal policy in this country has supported and facilitated arbitration for many years. We are a pro-choice jurisdiction in that sense. We don't force parties to go to court. We are very happy if they arbitrate. And the courts will help a tribunal, including the Bet Din, with making orders to ensure the fair and smooth running nature of the arbitration, to preserve property, for example, or items which are the subject matter of the case. And of course, the courts will enforce the award at the end. Over and above that, the courts in this country will be very reluctant to hear appeals from arbitrators. Appeals are heavily circumscribed and limited by the Arbitration Act 1996. And to distill it to a single sentence, provided the tribunal has conducted a fair hearing and hasn't made a really bad error of law, the court won't intervene. And in any event, the error has to be an error of English law in any event. There have been cases, however, where the English court has refused to enforce an award of a Bet Din because, for example, the Bet Din gave effect to a contract which was illegal as a matter of English law. And any bet din must be very careful, particularly if it's obtaining expert evidence to assist it, to ensure that both parties have a proper opportunity to make submissions about that expert evidence. There have been cases where the Dayanim have gone to an expert and received information without telling the parties what they were doing or allowing them to comment on it. And also, Dayanim must be very careful not to hear submissions directly or indirectly from just one of the parties. The chat in the corridor after Mincha is, I'm afraid, a frequent occurrence and one which has to be guarded against. There have been, however, some amazing cases. There was one case in English court where expert evidence was heard from Dayanim, including Dayan Aaronsro, may he merit a speedy recovery, for whether an ikul, a type of freezing order, operated in a way which English lawyers would call in persona, i.e. only against the party to whom it was directed, or in rem, whether it actually froze the property against the whole world. So in light of all of that, and because it's so easy to appoint a bet din under the Arbitration Act 1996, I think one must encourage members of the Jewish community to consider using the bet din to settle their disputes. As the previous speakers have said, that is a religious imperative, but it also makes commercial sense. Arbitration is commonly used to settle commercial disputes. And once you are arbitrating, why not arbitrate in the bet din? But that means, I think, we need to be sure of a number of things, and let me set them out. First, our batei din have to be fit for purpose. They must comprise Dayanim who have the commercial understanding to enable them to decide disputes. They must use procedures which make sense in the modern world. They need to use technology. They need to consider holding hearings over Zoom. They need to pre-read documents to save time in the hearing, and reducing the time of a hearing reduces the cost to the parties. They need to consider the use of written and not just oral evidence. You do need to have speedy procedures. Proceedings can't be open-ended. If people think proceedings are going to be open-ended, they will simply go somewhere else. There does need to be finality in litigation. Justice delayed, people say, is justice denied. But a case which never reaches its end is not achieving justice either. So that's the first point. The second point is that our institutions have to lead by example. If I want to hire a hall in Bevis Marks, does the contract which I sign have a bet din jurisdiction clause? And if not, why not? It looks from the website that if I buy tickets from the Sephardi.org website, that contract is governed by English law and not by halacha, and is subject to the exclusive jurisdiction of the English courts and not the bet din. Why? If our institutions, especially those which maintain a bet din, do not themselves use the bet din in their contracts, it is a little difficult, I would suggest, to exhort the members of our community to do so. That's the second point. The third point is perhaps the most important, and it's certainly the most difficult. We need to ensure that halacha is actually capable of dealing with real modern disputes, including large ones. The commercial world, I have to tell you, is not a world in which Reuven lends Shimon £100 and Shimon says he only borrowed 80. It is a world of companies. Does halacha recognize separate corporate personality? And if it does, what are the limitations on that principle? It is a world of cross-border transactions. Does halacha recognize the validity of foreign legal systems? And if so, to what extent? It is a world where different courts in different countries can and will make rulings on related issues. Will a bet din recognize and give effect to a decision of a secular court in the same country as the bet din is sitting? If so, to what extent? And what about the rulings of secular courts in other countries? Will the bet din recognize those? Because I would suggest that if we believe that halacha really is a system capable of meeting the needs of the modern Jewish community in the modern world, these are questions which have to be answered. And when I say have to be answered, I would suggest that the answers need to come now. It's no good saying, that's a really interesting question, we're still thinking about it. That is not an effective answer. And we are not going to find the answers, I respectfully suggest, in responsa written in the Middle Ages, or frankly at any time before about 50 years ago, when the Jewish community was very different, when business was very different, and when secular courts and their attitudes to Jews and Jewish life were also very different. We won't find the answers there, but we will, of course, find principles, and we will see the way in which those principles were applied to those communities, to their commercial world, and to those times. And our job, or may I respectfully say your job as Dayanim, is to work out how to apply those principles today to our communities, to our business world, and to our times. This, I believe, is the challenge of our age, to ensure that halakha speaks to us and meets our needs, including our commercial needs, to create a halachic system which can deal not just with what one might call Reuven and Shimon cases, but with the refinancing of an oil rig, or the issue of asset-backed securities on an international exchange. After all, English law can deal with those cases. Are we saying that English law can do what halakha cannot? How that is to be done is of course the province of the Dayanim and not me. And there is no finer example, if I may respectfully say, of a Dayan who is keenly aware of these issues than my friend and Chavruta Dayan Dadun. It's a privilege to share a virtual platform with him this evening, and of course with all of the other very distinguished contributors. I think there is going to be a facility for Dayan Dadun and myself, if time allows, to take any questions. We can either do it orally or we can do it on the chat. But let me conclude by thanking the S&P and the organisers of this conference for including me this evening. Thank you.
Thank you, Lord Wolfson, for that very interesting talk. And yes, we do have 5 minutes or so for any questions and answers directly related to the last two talks. If you have any questions, feel free. Yes, so Rabbi Grunwald asks, with respect to Rabbi Grunwald is a mediator himself, based in Gateshead. With respect to Lord Wolfson's question as to whether a Beit Din will uphold the decision of a court in various situations, surely a real challenge arises if the halakha would not, but the Beit Din would be unable to follow that under the Arbitration Act. How would we deal with this?
Well, I'm not necessarily sure this is an Arbitration Act point, but what I would say is this. If you're going to have a legal system which other legal systems will recognize, you have to think about when you're going to recognize other legal systems as well. The English court, for example, will give effect to an Israeli court decision, even if the ruling of the Israeli court was not what the English court would have done, because the parties have gone to the Israeli court. I'm not just saying Israeli court because it's a Jewish court. I mean, any court, frankly, with very few limitations. I do think there's a lot to be said for rethinking the principle of Dina de Malchuta Dina. Dina de Malchuta Dina, it seems to me, is Jewish law's attempt to deal with conflict of laws, what English law is called conflict of laws. And I don't think it's a surprise or it's an oddity that we find Dina de Malchuta Dina in the Babylonian Talmud, but not in the Jerusalem Talmud. The Babylonian yeshivot had to deal with Dina de Malchuta Dina. The Jerusalem rabbis didn't. I think in our generation, we need to recognize that if we want other courts to recognize and give effect to the rulings of our Batei Din, we need to think much more carefully about how we are going to give effect to rulings of secular courts, even if their decisions would be contrary to halakha or different to halakha.
Lord Wolfson, another question. Section 13 of the Arbitration Act 96 applies the Limitation Act to all arbitrations under English law, which is a mandatory provision. Sorry, how does this square with Dayan Dadun's comments?
Well, that actually is a very big topic. The question which rule of limitation applies does depend on whether you see limitation as a procedural or a substantive rule. And the lawyers on the conference will know what I'm talking about. Can I suggest, if whoever asks that question wants to email me, you'll find my email address online. I'm happy to discuss that, but it's pretty technical, and I don't want to take time up with a pretty technical question, though it's a very good one.
One final question, which touches more on what Abba Shavais is talking about, but I think it's still relevant, is that Dayanim, Dayanim Rabbanim, they're not regulated. There's no professional training. They're not answerable to any body, and therefore they're not accountable. So an argument can be made that the incentive of the Dayanim is to win at any cost and not to be straight and honest. What's the opinion with regards to that? Is that the fact they're not accountable to professional board a deficiency?
I don't know. Is that directed at Diane Weiss or to me or Diane Dadu?
I think it's for both of. I think it's for both of yourselves. But maybe Lord Wolfson from a professional perspective.
Yeah.
We know that the bar, there's training, and you're accountable to various bodies. You simply don't have that with the Dayanim Rabbanim.
Yeah. Well, I mean, here you are touching on something which is quasi-governmental, because one of the things the government is looking at is to what extent non-regulated advocates, known as Mackenzie Friends, should be perhaps regulated. I think the question is this. I think it would be useful to have a central system of Dayanim. And I understand that in Israel, I think there is, at least unofficially, such a system. And I think it might be quasi-official as well. I think one of the problems is that when you're dealing in particular with Batei Din in the diaspora, and also with a Zabla Bet Din, i.e. an ad hoc Bet Din, it's quite difficult to say to a party, you can speak yourself, you can pay for a lawyer, but you can't bring a friend. And I think that's the problem. I think ultimately it's a matter of the arbitrators controlling their own process. What I would do is I would make every Toem disclose whether they're charging, whether they're being paid, whether they've got a financial interest in the outcome of the case. Because I have heard of cases where Dayanim have actually had a financial interest in the outcome of the case, but the Bet Din wasn't aware of that. And it seems to me that's something of which the Bet Din must be aware.
I see. I think I might add that in Yerushalayim itself, the Dayanim Rabbanim who pass there is a regulated body that tests them and makes sure they are obviously regulated in order that they'll be able to act in Bet Dins in Yerushalayim at least. Maybe it's something that we need to do also anyway. Definitely something to do so.
Okay, I think further questions we're going to take at the end. There is going to be a time at the end of in just a half an hour or so for further questions. But I do really want to thank Lord Wolfson and Dayan Dadun for their contributions this evening. Lord Wolfson has been an incredible assistance to the Bet Din. Whenever we have any legal issues, he is there to answer us and to give us the legal advice. But we thank you very much for that, Lord Wolfson, and we're very happy that you're with us here this evening. We now move on to Dayan Ofer Livnat. Dayan Livnat, I am extremely delighted to be considered a Talmid of Dayan Livnat. Dayan Livnat serves as a Dayan on our Bet Din, a graduate of the Eretz Chemda Institute for Advanced Studies in Yerushalayim. Dayan Livnat teaches in a number of programs for training rabbis and Dayanim, including the Semicha and Dayanut programs run jointly by the Montefiore Endowment of London and Eretz Chemda. A lecturer on Tanakh at the Jerusalem College as well, Dayan Livnat has previously served in an artillery unit in the IDF and is currently studying for a PhD in Jewish Studies at UCL. Personally, I would like to say Dayan Livnat is one of the most patient Rabbanim I've ever had, answering all my many questions, and it's a delight and honor to be able to introduce him. Dayan Livnat is going to be talking to us on language and interpretation of contracts.
Okay, thank you, Rabbi Kada, for your very kind words. Birshut Rosh Beit Adin, all the Dayanim, all the Rabbanim that are participating, Special thanks to all the speakers and to Lord Wolfson for his very important comments on arbitration law. Just before I get into contract interpretation, certainly in the work of a Beit Din, we very much want to have the ability to our decisions to be enforced, and that's why we carefully follow arbitration law. When I was appointed to be a Dayan, I was given a very, very thick book on UK arbitration law. I can't say that it's exactly a page turner, what we would call, but nevertheless, it does have important material that we need to take into account. So to try to maybe rise up to the challenge of Lord Wolfson, how we can draw on principles from the sources which deal with economic situations very different from our society, but nevertheless, we can gain from them principles that we can apply today. I would like to do this regarding contract interpretation. In the work of a Beit Din, contract interpretation is very important. Why? Because often when sides, parties, they engage in a certain business together in a certain transaction, they'll have a contract, but the situation will arise in dispute where they won't exactly, part of their dispute anyway would be how to interpret their contract. One party would read it one way, another party would read it in a different way. And the question is, how do we go about, when the Beit Din now has to take a look at the contract and has to go through a process to interpret the contract to decide the dispute, how do we go about doing that? What does that process involve? This is obviously not just a Beit Din has to deal with. This is a very big topic for courts and arbitrators in general. And we'll try to look in the sources in Chazal, in the Gemara, to see what our sources have to say about this. So the first basic principle that we have to understand that when we get into contract interpretation is what we call in secular law freedom of contract, or what we call in halacha kol t'nai shebemamon kayam. Now, first bring a few sources on this point. I'll just share source pages on this. So the basic principle, again, as we call it, freedom of contract, is stated in many places in the Rambam. Kol t'nai shebemamon kayam. Any condition on monetary matters is valid. And if you look at the Rambam, he uses this in his many places. He uses this principle quite extensively. Both, it could be even a condition which runs contrary to the normal Torah rule. In other words, you could have halachot midoraita on monetary issues, but if a person makes a t'nai, a condition otherwise, then that condition is valid on monetary matters. It could also be a condition which runs contrary to the basic practice or the basic law. It could even be a condition, in some of the cases that the Rambam quotes this rule, a condition that heavily favors one of the sides, even extremely favors one of the sides. Nevertheless, we would say, kol t'nai shebemamon kayam. And as the Rambam phrases it in Hilchot Mechira, in the laws of sales, he says, V'hu adin lekol t'nai mamon she'omdim da'at hamatneh, ואין כוללים באותו התנאי אלא הדברים הידועים שבכללן היה התנאי, והם שהיו בדעת המתנה בשעה שהתנה. In other words, that on any monetary condition, because the validity of the monetary condition is because that's what the person intended, or that's what the parties intended, so we have to analyze what is meant by that condition. What did they have in mind? What did that person have in mind when he stipulated? What did the parties have in mind at the time that they made that condition? In other words, we have to sort of go back in time to when the condition was made and based on that interpret it. In other words, the most fundamental principle that we have in contract interpretation, in any interpretation on any monetary conditions, contracts, etc., is what was the intent of the parties. That's because that's the power of the condition. That's what they had in mind. That's what they stipulated. That's what they agreed upon. And therefore, the goal, ultimate goal of any contract interpretation should be to decide what did the parties have in mind, or the person who made that condition, what did they have in mind at the time that they did so. That's the fundamental principle. Now, the question is, how do we go about doing that? Because there could be multiple ways in which you could try to decide what did the parties have in mind? What was their intent? One possibility, especially if you have a written contract, is to try to look at the language of the contract, and based on that, to try to look very closely, examine very closely the language of the contract, and based on that, decide it. Another source that you could look for is the circumstances when the contract was done, perhaps the behavior of the parties in general, the normal practice of people. In other words, there are many different sources that one could look to. What we'll try to do tonight is analyze the issue of checking the language of the contract, the circumstances of the contract, and then we'll try to examine a situation where we have an apparent contradiction between the two, the language versus the circumstances. So let's speak about first the language of the contract. So interpretation of language of contracts is something that Chazal dealt with very, very extensively. If somebody learns especially Masechet Baba Batra, you see that the Gemara there does a tremendous analysis of many, many cases interpreting the exact language that was used by people and how each language should be interpreted. What does it mean? And sometimes the differences between the languages could be very subtle. Even one letter will change the meaning of what was the sale, the transaction that they agreed upon. I'll give just two examples, but again, there are many examples, especially in Masechet Baba Batra. So first example I would like to bring, where just one letter in a sentence changes, it creates a change in how it should be interpreted. So if somebody says, in other words, I'm selling to you a plot of earth required for the size of sowing one core, which is a measurement of seed. Okay, so now he asks, how do you measure that size of land? So the Mishnah says, if he said Beit Kur Afar Ani Mocher Lecha, Hayu Sham Nekaim Amukim 10 Tfachim Uslaim Gvoim 10 Tfachim Einam Nimdadim Ima. Pachot Mikan Nimdadim Ima. So let's say in the plot of land I have crevices or big rocks, the height or the depth of 10 Tfachim, a certain measurement, then because one cannot properly plant in those areas, they are discounted. You cannot take them into account, and the person will have to extend his plot of earth beyond those areas to reach the measurement where he can plant this Beit Kul. However, if he said, Im amarlo ke Beit Kul afar, in other words, he just added the kaf, one letter here, about a Beit Kul, afilo hayu sham nekaim amukim yoter ma10 tfachim, so because he added this one letter, Beit Kul, it's about a Beit Kul, that allows us to include even those crevices or big rocks, even though you cannot properly plant in them, but nevertheless they are included in the measurement of the land because of that subtle change in the language. Another example, here's a case where somebody was selling a land and palm trees. And the question is, how did he phrase the relationship between the land and the palm trees? That also will make a big difference in how the sale is interpreted. So the Gemara here says, also in Baba Batra, Amar le ara vedikle. Here the language was ara vedikle. He sent him land plus palm trees. So the Gemara says, Chazinan, iit le dikle, yaiv le tre dikle. In other words, if he told him, I'm selling you land and palm trees, then he has to provide him 2 palm trees. So if he doesn't have, he'll have to go out and buy them. Even if he has palm trees, but they're mortgaged, he'll have to release them of the mortgage. In other words, he has to provide them the 2 palm trees. If he said not vedikle with a vav, but he said Arabedikle, then that means Chazinan, iit bedikle yaivle v'ilav mekachtaut. The phrase Arabedikle, in other words, it wasn't land and palm trees, but it was land bedikle, which means with palm trees. Then the land itself the palm trees themselves must be on the land. He can't provide palm trees that are elsewhere, and if the land does not contain 2 palm trees within it, then the sale is not valid. And if he changed it just a little bit more, Ara Beidikle, in other words, a land of palm trees, Leitle Dikle, Dechazia Dikle Kamarle. Then even if the land does not have any palm trees on it, the sale is still valid. All that he meant was Ara Beidikle, he meant that the land was fit for palm trees. In other words, that it's a land that one could plant palm trees on them, even if there are no actual palm trees there. So we see here, again, another case where just a very subtle change in the language denotes a very different meaning. And there are many, like I said, there are countless examples of this. So in other words, the first principle that we have to be very, very careful when we interpret the language, and even very subtle changes, we should derive as precise as we can from the language of the contract. However, just one disclaimer to this point: it doesn't always necessarily mean that translation should be based on the literal meaning of the words. Okay, there are cases that we will not accept the actual literal meaning of the words, but we will add sort of a little bit to their meaning. For example, we have a case in the Mishnah in Kiddushin where a man said to a woman, "Haomer li isha ve'at mekudeshet li al minat she'arech 200 zuz, harei ze mekudeshet v'yar'eh la. In other words, if he made the condition with the woman that he's betrothing her on the condition that he will show her 200 zuz, 200 of a certain amount of coins, then the marriage will be valid, provided that he fulfills the condition and he shows her these coins. What happens if he shows her coins that don't belong to him? He has not fulfilled the condition. Why? Because even though technically the literal meaning of the words is just that he will show her, clearly what the intent was that he will show her coins that belong to him. It's not very helpful to her if he shows her money that does not belong to him. This is what the Rambam also says when he brings this halacha. He says, in other words, that I will show you that I own it. That's clearly the meaning of the words. In other words, even though we're very careful about the language, that doesn't necessarily mean that we will follow the literal meaning of the words. Rather, we sort of have to look in depth into the words to see what they mean, as in this example, that when he said he will show her, he meant he will show her of what he owns. What about circumstances of the contract? Circumstances of the contract are also very important. Again, we'll bring a few examples from Masechet Baba Batra that the circumstances are also taken into account. So there's a question. Let's say somebody's selling a wagon. A wagon usually comes with a pair of mules that pull the wagon. So if I say to somebody, I'm selling you the wagon, does that include the mules or does that not include the mules? What is the intent? So the Gemara on this says, Tani Rav Tachlifa bar Ma'arav Kamei de Rabbi Abahu machar et hakaron machar et hapredot v'ha'anan lo machartnan. So we have a contradiction. Are the mules included in the sale of the wagon or not? Amar le'isami, amar le'lo, titarge matnitach ba'adukim bo. In other words, the conclusion of the Gemara is it depends. Were the mules fastened to the wagon at the time of the sale? Based on that, we will determine. In other words, we can see based on the circumstances. If he said to him, I'm selling you a wagon, and the mules at the time were not attached to the wagon, then the sale does not include the mules. If the mules were fastened to the wagon at the time of the sale, again, based on the circumstances, we will interpret that the mules were included in the sale. Another example of interpretation by circumstances is the Gemara discusses Itmar hamocher shor lechavero v'nimtza nagchan. In other words, he sold an ox to somebody, and it turned out that this ox was prone to goring. So is that considered a blemish in the sale that would void the transaction or not? So the Gemara brings two opinions on this. Rav amar reize mekach ta'ud, u'Shmuel amar yechol omar lo lishchita mechartiv lecha. So according to Rav, the sale is void. While according to Shmuel, he said, I was selling you the ox not to be used for plowing, which is the normal use for ox, but rather I was selling it to you to slaughter it. So if you slaughter the ox, it doesn't matter if the ox, has a temper and tends to gore, you're anyway going to slaughter him. So the Gemara says, this whole question can be resolved based on the circumstances. How? The lichze. In other words, we can check, is this a person that usually buys ox for plowing? Is he a farmer that needs ox for plowing? Or is he a person that has a slaughterhouse and usually buys oxen for slaughtering? Based on that, we can determine what was the goal of the sale, and based on that, determine whether it's a problem that the ox is prone to goring. Or another option that the Gemara says is, we can check by the price that was paid for the ox, because a person will pay a higher price for an ox that is used for plowing than he would use for slaughtering. So therefore, we see here again the use of circumstances as determining here what was the purpose of the sale, whether it was for plowing or for slaughtering. And based on that, it will determine whether, if it turns out that the ox is prone to goring, whether that will cancel the sale or not. Okay, so that's all very good. So we'll check the language, we'll check the circumstances. What happens if we analyze the language and it seems one way, and then we look at the circumstances and it seems that the intent was otherwise? Which will be decisive? Will the language override the intent as appears from the circumstances or whatever else? Or do we say, no, the intent as we understand them from the circumstances has more power than the language? So on this case, we have at least one source, again in Masechet Baba Batra, that seems that the language is actually more powerful than the circumstances. This is a very famous Mishnah. It's talking about a case where machar et hatzemed lo machar et habakar, machar et habakar lo machar et hatzemed. In other words, tzemed is the yoke, and bakar is the oxen that are placed under the yoke again for plowing. So let's say I sold tzemed. Tzemed, the yoke, linguistically does not include the oxen. So therefore, if I sold the yoke, that's all you receive, the yoke. You won't receive the oxen, which are obviously much more expensive. Rabbi Yehuda Omer hadamim modi'im. Rabbi Yehuda says we can tell by the price. כיצד אמר לו מכור צמדיך ב-200 זוז, הדבר ידוע שאין הצמד ב-200 זוז, וחכמים אומרים אין הדמים ראיה. In other words, according to Rabbi Yehuda, I can determine based on the circumstances, in this case the price, that the oxen are included in the sale. But Chachamim argue, and we rule like Chachamim, ein hadamim ra'aya, you cannot prove it from the price. Why? Because the language of tzemed is only referring to the yoke, and even though the price may be very high, which might indicate that the sale was intended to include the oxen, nevertheless, we go by the language and not by the price. On the other hand, so from this it would seem that the language has more power. On the other hand, we find in Masechet Nedarim, this is not by monetary issues, but by laws of vows, seemingly that we follow actually the circumstances rather than the language. And this is a Gemara in Masechet Nedarim. Tanya, כיצד אמר רבי יהודה, הכל לפי הנודר, היה לבוש צמר ועצר, ואמר קונם צמר עולה עליי, אסור ללבוש ומותר לטעון. היה טעון פשטן והזיע, ואמר קונם פשטן עולה עליי, מותר ללבוש ואסור לטעון. In other words, somebody who takes a vow that he will no longer put on himself wool or put on himself linen. What is that referring to? Is it referring to wearing wool or linen, or is it referring to carrying it as a load? So according to Rabbi Yehuda, you can determine that by the circumstances, and here we do a rule like Rabbi Yehuda. If he was wearing wool and it was very uncomfortable, and he says, I take a vow no longer to put wool on myself, we interpret it to mean wearing wool, as opposed to if he was carrying a load of flax and he was sweating from the load, then we interpret the vow to mean not to carry it as a load. So we see here, and because time is short, but there are several other cases that we see that actually the circumstances can override the language and the linguistic interpretation of the words. So what is the ruling on this? So just to summarize, there seem to be differing sources in the Shulchan Aruch regarding this point, whether the linguistic interpretation overrides the intent as determined from the circumstances or the reverse. The conclusion of the Nachal Yitzchak, Rabbi Yitzchak Elchanan Spector, in his commentary on Choshen Mishpat is as follows. מה שכתב המחבר האחד, דאין ללך אחר לשון הכתוב אלא אחר הכוונה, דקאי גם כן היכא דהווה אומדנה דמוכח. In other words, the resolution he makes is as follows. Normally, the standard application would be that the linguistic interpretation would override the intent as deemed from the circumstances. In other words, in normal situation, we would give primary value to the language. However, if we have what we call an umdena de muchach, in other words, that we estimate, we have a very, very powerful estimation as to what the intent of the parties were. In other words, it's something that's very clear and very proven. In other words, it's something that you really can't ignore. It's so powerful, then in those situations, we will say, no, we can determine that this was really the intent of the parties, and the language that they used was not completely precise. And in those situations, we would override the language by the intent of the parties. So to summarize, in the process of contract interpretation, what we're really interested in is the intent of the parties. We have to go to multiple sources to determine the intent of the parties. We have to look at the language of the contract. We have to look at the circumstances, anything else that can help us reveal the intent of the parties. And if we'll have a situation where the two don't seem to agree one with another, then normally we would give some primary value to the language rather than the circumstances, unless the intent as can be deemed from the circumstances so powerful in which and proven, in which case they will override the language of the contract. Okay, thank you to everyone.
Thank you, thank you, Dayanim Nat, for, as usual, elucidating the halakha so clearly. Our final speaker before we move on to the Q&A, 7:15 or so, is Yossi David, who's going to be speaking on agents' fees. Yossi David studied in Sharei Torah in Manchester and Ponovitch Yeshiva, where he subsequently joined the Darkei Hora'ah LeRabbanim, headed by Rav Mordechai Eliyahu for 13 years, and he received tzimicha from Rav Eliyahu and Rav Shalom Mesas. Since his return to London, he has continued to deliver popular shiurim on both halakha and hashkafa, and his opinion is sought after by many segments of the community. Dayan David's great knowledge has brought him recognition as an halachic authority, and he has been leading the SKA, Sephardi Kashrut Authority, over the last 2 years with tremendous success. Bechavod.
Shalom Bracha. Thank you to all the previous speakers. It was fascinating. Truth is, myself learned a lot from this, and I'm sure all of you too. So first, let me start B'rshut Rosh Bedin, Rosh Bedin, and also B'rshut Rabbanim HaChashuvim, Kahal Kadosh V'Nechbad. In the beginning of this week's parasha, we talk about Ele Mishpatim. There is a little Rashi who brings a Mechilta, and he questions about the juxtaposition of the previous pasuk in the last parasha of Lo Ta'aleh B'Ma'alot Al Mizbechi, which is connected directly to the service in the Bet HaMikdash. Why is Mishpatim both next to each other? And this is to teach us, says Rashi, and it's a Mechilta, that you should situate the Sanhedrin by the Bet HaMikdash, by the Holy Temple. It gives the Dayanim Yirat Shamayim, fear of God. That's the most important component Dayanim must have. When two people come for judgment in front of them, what does God want from me? And that Yirat Shamayim is what determines the Psak Din, and that's why there's great importance. And I feel now, which is Kahal Kadosh, that's a wide public listening to us, and the Bedin, you feel as the Vice mentioned, Elohim Nitzav Badat El. The Shechina is participating in this wonderful conference. So I thank the organizers for this opportunity. I'm generally involved more in kashrut, but the topic that chose for me to I chose was more obviously monetary, because that's the subject tonight. And I wanted to discuss the concept of agents' fees. Now, I'm fully aware that there are practices and there are what we call minhagim amongst agencies. And that's quite clear. Usually when you go and approach an agency, you sign a contract, there are not many arguments. It's quite clear the percentage you're going to pay, whether the deal is going to take place, you're going to pay, whether it won't take place, you're going to still pay. That's all quite clear. But generally what comes before Dinei Torah is usually private people. People are not professional agents. And they come and discuss some disputes. Sometimes you offer the deal to someone, the deal went through, can be a deal of millions, can be of hundreds of thousands. And you have to determine without any contract whether this man is due a fee or he's not a Jew. I'd like to split this into 3 different discussions, and I'll try and make it, I've not got a captive audience here, and I've got to be careful not to be too lengthy in my discussion. But first of all, I want to divide this into 3 different questions. The first question is when you appoint an agent on your behalf. The second one is when someone comes along without my appointment and suggests a deal between myself or between someone else and someone else. I know Lord Wolfson said that Reuven and Shimon matter, but we're going to use a little bit of Reuven and Shimon here. You can have Reuven wants to sell a house, Shimon is interested in buying, and someone without being appointed comes and suggests this, what we call a shidduch. By the way, shidduchim work in a very similar fashion. I was always in a view, I always thought it's more amongst the Ashkenazi world that they charge for shadchanut money, what they call to matchmaking money, and they're professional shadchanim. But apparently, back in the sources, you see that there was a widespread custom even in Sephardi countries. I think in Iraq it was called dalal, yeah, someone who would go around matchmaking and he would charge good money. People were frightened to meet him on the street. You had to be on perfect this, but the same question would come there. So he's not appointed, he approaches the people and he makes the match. He's not a shliach. The third discussion I want to conclude with is, in many circumstances, the agent, or what we call the agent, didn't really participate in making the shidduch. All he did is referred you to someone who he got information that he wants to sell or he wants to make a deal. So he didn't actively take a role in trying to bring these 2 people together. Or he brought about the idea. Can he now turn around and say, I deserve an agent's fee for that? Yeah, sometimes it can be big money. And it's quite a Jewish trade. Jewish people like making deals because it's not much effort and it's got a lot of money because you work by percentage. It gives you a bit of peace of mind. You don't have to work day and night for money. And that's seems to be what we call property. Anybody dealing with properties, that's what he's doing, matchmaking, yeah? So let's begin discussing with the first discussion about if you appoint an agent. The source for this is the Rambam says quite clearly, Hasarsur hu shliach, ela shemekabel scharo. A sarsur, which is an agent, the Rambam writes that he's a shliach. However, the difference between a normal messenger and him would be that he's getting money for what you appointed him for. So that's quite clear. You don't even have to make an act of acquisition. You don't have to sign the document. I mean, there's a practice in the country, there's a practice by people who make deals. If you appoint a shliach, this is the value of an agent. It takes 1%, 2%. It all got to do with the custom, and that's undisputed. When we say minhag mevatel halacha, if there's a practice amongst businessmen that can even nullify a halacha, meaning generally we cannot take money from someone else without bringing a proof. However, if there's a custom and a practice that's as strong as a proof, and you can even take from a muhzak, someone who's holding money, his own money, you can take money from him based on the practice. Okay, so that's quite clear. We won't go much into this first point. The bigger issue is when you don't appoint a messenger, you don't make a shliach, you don't appoint him as an agent. He approaches you, he approaches the buyer, he approaches the seller. So he hasn't really approached his messenger, and then he turns around and says, I want to cut in the deal. I'm the one who made the shidduch between you. And the guy turns around and says, what are you talking about? I never agreed. Thank you very much. You've done a great service for me, but I never signed on anything. I never agreed on anything. You came and ran after me, and you probably even convinced me to sell, and you convinced the other one. That's very kind of you. Shalom Aleichem. However, you should know that the great Ran in the 13th parak of Tuvot, Shnei Dayanim Gzerot, brings in the name of the Rashba a very important principle which the Rama, Rav Moshe Isserlich from Krakow, brings in Siman Resh Samach Daled in Choshen Mishpat. Haoseh פעולה או טובה לחברו, someone who does a job, פעולה, or he does a favor to someone else, he cannot turn around the person who received this favor and say, oh, you did it for free. Not at all. Even if he didn't condition that he's doing it for a payment, if he benefited from this and he made money on this, he cannot turn around and says, I don't have to pay you anything. This is repeated in Siman Resh Mem Vav in the name of the Trumat Hadeshen. The Trumat Hadeshen brings that if someone tells his friend, let her come and eat by me. Let's give an example today. Small example. Let's go to a restaurant and eat. And they go and eat. And then he takes his credit card and pays. As they walk out the restaurant, his friend turns around, hey, I want half of the charge for this meal. Says the Rama in the name of the Trumat Hadeshen that he has to pay the money. We don't say that if someone paid expenses, went through this, you don't turn around and say, oh, you did it for free, you did it as a favor. So these two rulings of the Rama seems to be quite clear, and it's learned from the Talmud in Bava Metzia, page 101. The Talmud says, Hayored letoch sdeh havero, someone who goes to the field of his friend. Now he knows year after year, his friend is planting that field and growing it and harvesting and selling. So he goes without his permission and he plants it for him and he does all the work. Then he turns to the owner and says, pay me. So the Talmud says, if he's a man who normally does the year after year this, he's got full right to get his payment, not only for the costs and expenses for everything he's planted, also for the work he's done, even though he never instructed him to do so. And that's a clear Talmud in Bava Metzia. There's a Talmud Yerushalmi in the beginning of the 5th parak of Ezer Unesher, which brings something similar. Someone borrowed money from someone else. Reuven borrowed money from Shimon. And Reuven now owes the money to Shimon. And Reuven tells Shimon, can live in my house. Please use my flat across the road. And Shimon goes, lives over there. After a few months, Shimon turns around to Reuven, where's my loan? I want my money back. I lend you money. Reuven turns to Shimon and says, what are you talking about? You lived in my house for a few months. Please deduct that from the loan. The Talmud Yerushalmi says he's fully entitled to do so. The reason why I'm bringing this Talmud Yerushalmi, because I want to bring a slight contradiction. And I want to give an example of, unfortunately, there has been amongst the halachic authorities, they could not get hold of earlier responses, which were not widely, there used to be manuscripts, but they never saw it inside. So therefore the ruling was subject to their understanding. And later on, when these responses came about, clarity came. The great Rama, Rav Moshe Isserlich, again, third time, in Siman Shamas Shin Samach Gimel and Choshev Mishpat, brings an interesting tashbetz. Rabbi Shimon ben Tzemach. There's two tashbetz. There's Rashbatz and tashbetz. There's an Ashkenazi tashbetz, which is called Tashbetz Katan, which is a student from the Maram de Rothenburg. And there's a tashbetz which was Sephardi, lived approximately 600 years ago. Approximately 577 years before he passed away. And he's called the Tashbetz, Duran. And he mainly lived in Algeria, and he wrote responses. And the Rama Moshe Isserlich rules in Siman Shin Samach Gimel as follows. If someone Reuven told Shimon, come and live in my house, come and live in my house. And then after a year, he comes back and he says, give me payment for the time you lived in my house. Says the Tashbetz, he doesn't have to give him a penny. Doesn't have to give him any money. This seems to contradict the past two rulings of the Rama. How does that go together? I'm being very brief. Yeah, maybe with time we can discuss this in further depth and look at the differences. The great Bach, Bet Hadash, Rabbi Yoel Sirkish, the commentator on the Tur, who lived approximately in the time of the Bet Yosef. He was a student of the Marshal, Rabbi Yosef in that time. And he writes, he brings this tashbetz and says this is arguing with the previous two rulings of the Rama, which he brought in the name of the Trumat Hadeshen and the great Rashba in the Ran, which you mentioned previously. And therefore, his ruling is that if someone did a favor to someone else and he didn't clarify that he's doing it with a charge, then we've got a dispute between the tashbetz and the other two sources, whether you can take money from the person you did a favor to or the person you did work for. And therefore he leaves it as the famous ruling, hamotzi mechavero alav hareaya. And the claimant, the one he's claiming for, can turn around and says, Kim li tashbetz. I hold like the tashbetz, like the ruling of the Ramayana Shin Samach Gimel, and therefore I don't have to pay you. Or if the other person is muhzak, is holding the money, he rules it hamotzi mechavero alav hareaya. So that puts the whole agent's fee in dispute here. Seems to be that if you don't clarify before that you're doing it for money, there's no agreement there. You can't turn around and say, oh, I did you a favor. I went and convinced this fellow. I made you the deal. I can get money. He says, no, I hold like the tashbetz. And you should know that the Bach not only rules like that, the great Siftei Kohen and the great Turei Zahav and the Netivot HaMishpat and even the Sephardi halachic authorities of hundreds of years ago, Ramari Castro and Erech Lechem, also rules the same. Hamotzi mechavero alav hareaya. Now the truth is, this began with a slight inaccuracy in the tashbetz. Not in the tashbetz, in actually not seeing the response of the tashbetz. The tashbetz was never printed in the time of the great Bach, Bet Hadash, and in the time of the Siftei Kohen. The tashbetz was printed approximately about 280 years, yeah? So they never saw the response inside. In the response inside, it's quite clear that the tashbetz is talking about a person taking his private home and he's traveling overseas, and therefore he doesn't want to leave his home alone. And he turns to this friend and he tells him, please, live in my house. Yeah? So in that case, there's a concept of zene neve zelo chaser. He's not planning to rent his house out. So therefore, he's doing a favor to the person who's asked him. And that's why the tashbetz says he doesn't have to give him any payment when he comes back. So therefore, the ruling goes back to what we said. Interesting, you know who pointed this observation out? A great rabbi called the Chukei Chaim, Rabbi Avram Gagin. Rabbi Avram Gagin lived approximately 200 years ago. He was the great-grandfather of the Keter Shem Tov, who was a Rosh Av Bedin in England, here in the Spanish and Portuguese, in this great Bedin, which we are now in the midst of. He was a Rosh Bedin, Rabbi Shem Tov Gagin. His great-grandfather was a Chukei Chaim. He wrote a book called Chukei Chaim, and he makes this observation that these great rabbis did not see the response of the tashbetz inside, and that's why they ruled it as a doubt, and they said, hamotzi mechavero alav hareaya. You have to prove evidence in order to take our money. But based on now being able to find the response and see it and read it inside, we've settled this contradiction. I just want to conclude with the third, which we've got not much time, but let's go to the famous example where people introduce other people or point the fingers. Oh, he's selling a house. Oh, he's a good businessman. Oh, he's got investments. And upon that information, this person goes and does the deal himself without any help, without any agent's work. The great Ma'arach Rabbi Chaim Or Zarua defines what the payment of an agent is for. He says the payment of an agent is for the profession of being able to convince other people, to schmooze up people. You know, agents. I don't want to say, probably there might be agents amongst this conference listening to us. But you know how agents know how to work, how to show the good parts of things and hide away the other one. We know agents. They've got a sharp tongue. That's a profession. If someone has a good voice and he sings, he can also charge for his voice. So to an agent, he's convincing. Or some people are too embarrassed to approach directly. So the in-betweener is doing something here. Something. Interestingly enough, the Marach Or Zarua says that the payment for an agent is the fact that he's got the mouth that he's able to mediate, and he does that. He does the shidduch. But if he just stands back and points his finger and gives information, unfortunately, it's become a custom and a practice amongst people. Oh, I introduced you to him. Please give me. Not only that, not only for this deal, the next deal, and the next deal, and for 100 years. This thing seems to be not such a accepted thing in halakha. I'll just conclude that, interestingly enough, in Shut Minchat Asher of Rav Osher Weiss, I actually saw in the second volume, he writes these words, but he doesn't bring the Marach Or Zarua, but he says, logic says, if someone didn't actually intervene in the matchmaking, he just suggested something, or he pointed the finger, says, on what basis does he want money? I won't go into that case, how exactly it worked out, but Baruch shekibanti lidvarav. But this is great Rishonim say it, There's great proofs also that Ravad and Shita Mekubetzet Ibao Metzia Kufarev says something very similar, that if you didn't put any effort, therefore there's no room here to claim that you've done a favor, it didn't cost you anything, it didn't take off human time, you didn't need to convince anyone, you didn't need to matchmake, you only did it. So I want to conclude with this word and thank all of you for being patient enough to listen to this shiur. And Bezrat Hashem, how Dayan Bai said right at the beginning, we hope to see you all in person and be able to talk to each other in a much closer way. And Bezrat Hashem, Hotzia mi mazger nafshi leodot et shemecha. May Hashem take us out from this small prison. Let's not exaggerate, yeah? Let's not exaggerate our situation, but take us from this enclosure we are in and bring us out kedei leodot et shemcha, in order to thank you, Hashem, for everything. So I thank the Rabbanim HaChashuvim, the Kahal Chashuv Nechvad, and may you have a lot of Hatzlacha. Have a pleasant evening.
Thank you very much, Dan Yossi David, for those interesting shiur on agents' fees. We have now 8 minutes remaining for any questions and answers before we hand over to Senior Rabbi Joseph Dweck, who's going to give us some closing remarks, and we will finish at 7:30 promptly. So if there are any questions, feel free to send them through. Any questions for the Dayanim, for Lord Wolfson, for anyone else, please do feel free to send them through now. So one question which came in is, how does Peshara work regarding an appeal? Normally, Peshara does not allow an appeal, even if you have new evidence or arguments. And in truth, it would be worthwhile to discuss, actually, whilst we have the benefit of Lord Wolfson with us, the concept of appeals generally in a Bedin. I know many times people ask, is there an ability to appeal the decision of a Bedin? And this is unlike the secular courts where you do have the ability. So maybe Lord Wolfson, what are your thoughts on that, the inability to appeal a Bedin decision?
I don't see that as a problem, certainly not from the perspective of English law. Most arbitral bodies don't have appeals built in within the body. So if you have an arbitration under the LCIA, the London arbitration body, the main one, or an ad hoc arbitration, there's generally no appeal within the arbitral body. If the Bet Din is sitting in England as an arbitrator in England, like any tribunal, there's an appeal to the English court. But as I said, that's a very limited appeal. It's not an appeal that the English court thinks the Bet Din got it wrong. It would only really be, as I said, if there was something fundamentally wrong in the procedure. The Bet Din didn't listen to one of the parties, or it decided it on the basis of evidence which one party wasn't able to address, or something like that. So the absence of an appeal mechanism, certainly from the point of view of English law, is not a problem.
Any comments, Dayanim? Would you like to add anything?
I think the question that was asked here was really, should there be an appeal like there is in Eretz Israel? When the Bet Din in Eretz Israel, when needs to be appealed, then they go to the Bet Din Agadol. I think that was the question. Is there a possibility that Batei Dinim, according to English law, have a body which will be able to receive those appeals?
Yeah, I mean, as a matter of English law, you could have an arbitral system where within the arbitral body there was scope for an appeal. Whether that's wise, I'm not convinced. I think you need to recognize that the Batei Din in Israel sit somewhere between arbitration and court. I mean, I know formally it can be seen as arbitration, but it is essentially a separate court system to a great extent. And therefore, if it's going to have credibility, it needs to have an appeal system to the Bet Din Hagadol, because there isn't an appeal system to the secular courts in Israel. So I think we may be comparing apples and oranges when we're thinking about Batei Din in Israel and Batei Din in the diaspora.
Okay, thank you for that.
So, Lord Wolfson, what would you suggest?
I would suggest that if you built in an appeal system, I think it would create more uncertainty, more cost, and would make it less likely that people would come to Batei Din. I think also, I think in Chutz La'aretz, in the diaspora, frankly, you're going to struggle to have enough people to populate properly Batei Din and an appeal system as well. So I'm not sure that it's either necessary or worthwhile, but that's very much an off-the-cuff reaction. So it probably merits further thought, but I'm not immediately attracted to it.
Mm-hmm. Okay, I just want to squeeze in one more question whilst we have the time. Can the Dayanim advise on the ability for a Bedin to enforce its decisions apart from the Arbitration Act? Maybe Dayanim, maybe?
Well, I think the most correct way to enforce it is the Arbitration Act. There are Batei Din, and we know in certain very closed communities that, you know, have enough authority within their community that they're able to enforce their decisions by the mere community pressure that there is within those communities. For the general public, for most communities, that's probably not the correct approach nor the practical approach. There was even recently, unfortunately, a case of a certain Beit Din in a different country that was held in contempt of court for trying to overly enforce their decision when it wasn't run according to arbitration law. So I think for the general practice for most Batei Din should be to follow arbitration law. It's not very complicated, as Lord Wolfson said. You just have to be fair, which is anyway required al pi halacha. So if you're following a halacha, then you're also by definition following the requirements of arbitration law, and then the courts can enforce it, and that's fine. That's the derech hamelech. That's the proper way to go by.
Dayan David, okay, anything to add before we wind up?
I think Dayan David would like to say something on that point.
Dayan David, maybe unmute. I think we're going to end with Rabbi Dweck. Dayan David, B'chavod?
But really, when it comes to a Beit Din, generally, the Beit Din, people are familiar with the Beit Din. They recognize the Dayanim as God-fearing, and the trust in the Dayanim will depend very much on, will make them come forward if they know about it. It's not like a go to court where you don't know who the magistrate is, who the judge is, and it becomes very official and cold. The Beit Din, the litigators can face each other, and they feel secure and they feel confident, and therefore they're given much more opportunity to express themselves and what they do. And therefore, it's really, if they try it, you will see that really it's an ideal way to settle in disputes, bring shalom into our kehilot.
Thank you very much for that. Thank you, Dayan David. So we're going to end now with Senior Rabbi Joseph Dweck's closing remarks for this event. Rabbi Dweck is the Senior Rabbi for the S&P community, the country's oldest Jewish community. He studied in Yerushalayim at Yeshivat Chazon Ovadia under the tutelage of Chacham Ovadia Yosef. In his capacity as Senior Rabbi, Rabbi Dweck serves as President of the Council of Christians and Jews, Deputy President of the London School of Jewish Studies, Ecclesiastical Authority of the Board of Deputies, and Standing Committee member of the Conference of European Rabbis. Rabbi Dweck is going to make a Misha Berach for Dayan Ehrentreu for his Refuah Shelema, and we are honored to have with us Rebbetzin Ehrentreu, Dayan Ehrentreu's wife.
Thank you, Rabbi Kada. I want to first thank on behalf of the entire Kahal, the Dayanim, the illustrious Rabbanim that opened, Rav Amar, Rav Lau, and of course Rav Weiss, who in his great care for the work of our Beit Din took his own personal time and spoke to us live. We are very grateful for that. And of course all of our Dayanim, Hashem Yishmerehim v'chayehim, Yafitzu ma'anotam hutza, יושבע מדין. הקדוש ברוך הוא שמברך את כל מעשיהם, that they should be מכוון לאמיתה של תורה. We are very grateful to be able to have them, בראשם Dayan David, Dayan Livnat, Dayan Dadun, and all of the Hachamim that were included. Thank you so much, Rabbi Kada. We look forward to you and your Dayanut And thank you, Dayan Yossi David, the head of our kashrut, who watches how you watch with such care and such meticulousness to make sure that all is done kadat v'chadin in the kashrut. And thank you, Lord Wolfson, for your kindness, for your care, and for your attention to all it is that we're doing, and for your invaluable contribution. I also want to thank those who did a tremendous amount of work to get this put together. This doesn't just come together on its own. There are people who work very hard for this. And I want to thank Dr. Elisha Khan, Mr. Sinakain, and our board member, Dr. Efrat Sofer, and our office staff, who worked very hard day and night to make sure that this conference, unique in its kind, came together well. Hashem yishmerehim v'chayehim, and the Temaskutam Shelema. I want to end with the following point. It's been said tonight that our Bet Din, the Bet Din of our Kahal, the Spanish and Portuguese, is the oldest Bet Din in the community, in the country. It is the oldest Bet Din in the country. Over 300 years, not 200 years, over 300 years old. Pretty much from day one of the establishment of the Kahal, we had a Bet Din. And this Bet Din is the Bet Din that these illustrious Dayanim sit on. And they sit on it with reverence, knowing that they take the seats of great Hachamim that came before them, and that they hold that tradition in their diyunim, in their judgments. When I met, we were going to say a tefillah for Dayan Ehrentreu. When I had the great zechut of meeting Dayan Ehrentreu for the first time, and since then, we've met many times and spoken on many occasions, and I have learned so much from the Dayan. This is usually what it looked like, meeting with him in his house. And the first thing that the Dayan said to me when I first sat with him was, he said, you know, Rabbi Dweck, when we write Gitin, when we in the London Bet Din write Gitin, we write the name of the city London and the name of the river, the Thames, which is required on the get, that it should be appropriately ordered. We write it like the Sephardim write it. Why do we write it like the Sephardim write it, he said? Because it's minhag makom, because it's the custom of the place, because you were here first, because the Sephardim were here first. And so that is how we write it in our Gitin. And Dayan Ehrentreu always asks me, always when I sit with him, he always asks me, how is the Bet Din? How are the Dayanim? All of our Dayanim, he would always ask after them and hear how things were going. Always wanted to hear how things were going on with the Kahal, and especially with the Bet Din. And Dayan Ehrentreu always is interested in what's going on with our Kahal. And I'm so grateful. And so shortly we will say tefillah for his refuah, that he should be strong and healthy and well, because we need him so much. I will say that I had the great zechut to be able to sit many years with Hacham Ovadia Yosef Zecher Tzadik Lebracha, to see how he spoke to Dayanim, to see how he led Batei Din. I saw him meet with Dayanim many times, and I saw him advise with them many times. And when I came to this country, it was not even a year after my Rav passed away, Hacham Ovadia. And I didn't find nehama, I didn't find comfort until I was able to sit with Dayan Ehrentreu. Because Dayan Ehrentreu reminded me of the strength, of the conviction, of the clarity of Torah that I used to see in Hacham Ovadia. And so we wish that he should have refuah shlema, and we will say a formal mishabarach for him in just a moment. But I have a surprise for all of everyone really that's here tonight. As we say a lot of times that the Bet Din is the oldest Bet Din, but I want to show you something. When I came into the Kahal, and as Dayan Ehrentreu said, it's minhag makom, you know, we write the name of the city and the river the way that the Sephardim write it. When I came into the Kahal, I saw how they were signing the ketubot. And I had a question on how the ketubot were being signed. And I felt that the ketubot should be signed a bit differently, according to halacha. And one of the people who were involved said to me, well, this is our minhag. This is our custom. And I said, well, I would like to check. And I said, I'd like to see the oldest ketubot that we have, because I knew that we had ketubot held in our archives. And so I visited the archives, and I saw the ketubot. And I saw a ketubah from 1724. And the ketubah from 1724 was signed by my predecessor, Hacham David Nieto, who was the Hacham of the Kahal, excuse me, I'll open it up for you.
It was there before.
It was, yes?
It was there before, so just do the same thing you did before.
1 second. Here, yes?
We can see it, yes.
You see it, yes?
Yes.
Imantov, yeah? So he was the Hacham of the Kahal from 1701. Hacham Nieto died in 1728. This ketubah is 4 years before he died. So you can see here, our ketubot still look the same design on the outside. We haven't changed it in over 300 years. And I wanted to see the signature, and thankfully I saw the signature as it was done by Hacham Nieto himself. And so we established that this signature should be that way. And so I wanted to show you the signature of Hacham Nieto from this ketubah. So you see here, down here, it says David ben Harav Pinhas Nieto. I'll show you here even clearer down by the Tnaim, his signature. David ben Kvod Rabbi Pinhas Nieto. That's Hacham Nieto's signature on our ketubah. That's how old our Bedin is, and our Kahal, and our Hachamim. And so I wanted to show that to you before we end tonight, so that we have a sense of what it is that we're dealing with here, who it is that we are here, and who it is that our Kahal is. And it should be never forgotten. And on that, for Dayanim Troy, reminding us, Minhag HaMakom, it's the Minhag of London is established by our Kahal. Would like to say with everyone, please have kavanah. And I know that the Rebbitzin is here, Rebbitzin Aaron Troy. We'll say a Mishabarach for the Dayan. Mishabarach Avotenu, Abraham, Yitzhak, Yaakov, Moshe, Aaron, Vishlomo. Hu yirapeh et acholei Dayan, Hanoch ben Belima HaKohen. El narafanalo, El narafanalo, El narafanalo. Shlach lo, Refuah Shlema, רפואת הנפש ורפואת הגוף במהרה. יקוים בו הכתוב, כל המחלה אשר שמתי על מצרים לא אשים עליך, כי אני אדוני רופאיך. וכן יקוים בו הכתוב, אדוני יסעדנו על ערש דווי. כל משכבו הפכת בחוליו, מתוך שור כל חולי עמו ישראל. וכן יהי רצון ונאמר אמן. חזקו ואמצו, שבוע טוב, ברוכים תהיו.
Thank you very much, Rabbi Derek, for those very interesting words and that fascinating ketubah of Chacham Nieto, and for showing how we Sephardim have been here for so many years, and that we will continue to lead the way, going just like we led the way tonight with this wonderful conference. We'll continue to lead the way for London and Bezrat Hashem for many other communities worldwide. So, dear participants,
I will say Meshibarach for all of the Holim. Also, now that the Dayanim are here. Meshibarach Avotenu Abraham Yaakov, Moshe Aaron Shemo, Hu yirapeh kol cholei Yisrael, shecholim bechol machalot. Kadosh Baruch Hu yihayem, vishlach lahem, refuah shlema, refuat hanefesh, urefuat haguf. V'chen yhi ratzon, v'nomar amen. Chabod.
Thank you very much. Just one final word. I just want to say hello to Dayan Navon, Yaron Navon, who was our Rosh Bedin for a number of years. Who's
Chabad Dayan Yaron Navon.
It was a very, very special Rosh Bedin. He was with us for many years, and I learned so much with him. It's such a pleasure to be associated with him.
Dayan Navon was with me when we went to the archives to see the ketubot. כבודו היה איתי כשהלכנו לאוצר, כן?
In any case, ladies and gentlemen, we hope to have many more events such as these. So if you've registered for tonight, please stay in touch. You'll receive further notifications of further conferences in the future. I want to once again thank our Rosh Bedin, the Dayanim, Lord Wolfson, Rabbi Dweck, and of course, the Kahen brothers, Dr. Elisha and Sinna, and Dr. Sofer as well, for all their incredible input, and also the entire team, Sebastian Herrera, Lauren Posner, and the entire team for all their work. Beruchim Tiyu, thank you so much for joining this Kiddush Hashem and wonderful evening of Torah. Have a wonderful week. Shavua Tov. All the very best.